Welcome to Your Legal Minds. In the last video, we covered the beginning of stage 2 of a misrepresentation question. We went over the first element of an actionable misrepresentation, which is a false statement. And now we are going to go over the second element of the second stage, which is that of a false statement of fact. So in other words, the statement must be a false statement of fact, not an opinion. It must be fact. Now, an opinion in law largely differs from what the layman considers an opinion, because an opinion in law is slightly different to an opinion in general terms. So in order to establish whether or not a statement was on a fact or whether a statement was an opinion, we need to contrast two cases, and those two cases are Bissett and Williams and the case of Smith and Land and House Property. In Bissett, a defendant was selling some farmland. However, this particular defendant had no knowledge of farming. He had never farmed before. He'd never farmed sheep before. And his statement was regarding the quantity of sheep that could be held on this farm. The seller of the farm made the representation that the particular farm could hold 2,000 sheep. And this was actually held to be an opinion. Now, before I say why, I'm going to contrast the facts of Bissett with the facts of Smith and Land House Property. In Smith and Land House Property, the defendant was selling a hotel. And he claimed that he had the most desirable tenant within this hotel. The words were something along the lines of, "I have a most desirable tenant." Now, that was essentially a false statement on the basis that the tenant was actually in arrears with the hotel. So the tenant was not most desirable at all. Complete opposite, as a matter of fact. Yet in Smith and Land House Property, the statement made regarding the tenant was held to be a fact. There are three reasons for this distinction, for the different outcomes of each case. Firstly, in the case of Bissett, neither party, neither buyer nor seller, had any knowledge of farming before. Neither of them had farmed sheep. So it was an opinion in that sense, because it's like, I'm not a psychology student, I'm not a practitioner in psychology, so if I made a statement regarding psychology, yeah, it may be true, but you can only rely on it as an opinion. You can't trust what I'm saying because I'm not a professional in that area. So in that sense, the statement regarding psychology would be an opinion. As opposed to in the case of Smith, where the seller of the hotel did have knowledge on the hotel. He had owned the hotel, so he had knowledge. He knew about the dynamics of the hotel. He knew who the tenants were. He knew about the dynamics. And in that sense, the buyer of the hotel could have relied on that statement because he knew that the hotel owner had knowledge in regards to the hotel. So that's one distinction between the case of Bissett and Williams and Smith and Land and House Property. Secondly, in the case of Bissett and Williams, there was an element of honesty. The seller of the farm made a somewhat naive, educated guess. He attempted to make an educated guess. There wasn't that element of honesty. It was to answer the question of the buyer, and that's all it was. It was a guess. It can probably hold 2,000 sheep. That was the guess. In Smith, however, the seller of the hotel knew the truth. The seller knew exactly whether or not that tenant was truly a desirable one. And in his mind, he knew that the tenant was in arrears with the hotel. It was definitely not the most desirable tenant. It was the complete opposite. It was, if you own a hotel, if one of the people staying in the hotel is in arrears with that hotel, then they're definitely not the most desirable tenant. So that's another reason these two cases led to different outcomes. And finally, this links to the first reason the two cases were distinguished is that in Smith, the seller of the hotel had specialist skill and knowledge in relation to that hotel, so he knew of the dynamics. So essentially there were two reasons, but this is partly the reason. You could say that this contradicts what I went over in the stage 1 video, where if one party has specialist skill or knowledge, then a statement is more likely to be a term. But the courts obviously take into account all of the relevant factors before arriving at their conclusion. But what about statements of law? Can statements of law form the basis of an actionable misrepresentation? Are they the equivalent to a statement of fact? Under the old law, no. Under the old law, it had to be fraudulent in order to amount to a false statement of fact and form the basis of an actionable misrepresentation. So it had to be deceitful. It had to be for the purpose of fraud. Now, that's not a requirement. And the case of Kleinwort shows that now statements of law can amount to false statements of fact. And I think the logic behind the old law was on the basis that because most people, the average person, doesn't have specialist legal skill and knowledge, that's why it couldn't amount to a statement of fact and it was more opinion. This makes sense because it's like in the case of Bissett, the seller of the farm had no previous experience with farmland. He'd never farmed sheep, he'd never owned a farm, and he just happened to sell the farm. In the same way, I think the reason why under the old law a statement of law couldn't amount to a statement of fact was simply because most people do not have specialist skill and knowledge in relation to the law. That's changed now, and the reason why it's changed is because under the new law, well, this isn't a fairly recent concept, but there's a phrase that says that ignorance of the law is no excuse, and I think that's partly the reason why this new law has come about, that a false statement of law can be a false statement of fact, because otherwise there'll be situations where a person will make a false statement of law and they'll say, well, I didn't know, I thought it was generally correct, and then the claimant may not be able to claim a remedy under the doctrine of misrepresentation. So now the law has changed, and I've actually got a quote from the case of Kleinwort. Sorry, not from Kleinwort. The quote is actually from a case called Pankania and Hackney London Borough Council, where the judge held that this is what he said. He said, I have concluded that the misrepresentation of law rule has not survived the decision in Kleinwort Benson Limited and Lincoln City Council. Its historical origin is an offshoot of the mistake of law rule created by analogy with it, and the two are logically interdependent. Both are grounded in the maxim, ignorance of the law is no excuse, a tag whose dubious utility would have been enhanced had it gone on to explain who was not excused and from what. And then the judge in that case went on to award a remedy to the claimant for the misrepresentation that had occurred, which was actually a statement of law, an incorrect statement of law. The next question is, what about statements of future intention? Can they be regarded as a statement of fact and form the basis of an actionable misrepresentation? The general rule is that no, they don't form an actionable misrepresentation, because they are only statements of future intention. They aren't really a fact, they're just of an intention, and something that is supposed to occur in the future is not a fact. It's you could say a prediction or a statement of something that will occur in the future. It's not necessarily a fact. However, there always seems to be a however in law. There are times when it can form the basis of an actionable misrepresentation. And just like it was with the previous law in regards to statements of law, the current law on future intention is that it can form the basis of an actionable misrepresentation if it was made fraudulently, as shown in the case of Edgington. I think I spelled it wrong on the slide. Make sure to add a G between the D and the I. And in this case, the claimant had invested a sum of money into a company because he was told that by doing so, the company would use that money to improve his business by using it to renovate his buildings. The money was actually used for the company's debts. So the company that made the statement used the claimant's money to pay off their own debts. This was held to form the basis of an actionable misrepresentation on the basis that it was made fraudulently, because the company knew that it wasn't going to go on the buildings, it wasn't going to renovate the buildings and improve the claimant's business. It was to pay off their debt. So if a statement of future intention is to form an actionable misrepresentation, then it must be made fraudulently. So that's the second element of stage 2. So far we've gone over false statement, and in this presentation, false statement of fact. In the next presentation, I'm going to be covering the final element of stage 2, which is that the false statement of fact must have induced the other party into the contract.